Welcome back to another episode of Case of Interest Kohberger. I'm Newswatch 16 Stacey Lang. This is our web series where we break down all of the latest developments in the University of Idaho murder case, which involves a person from our area, Brian Kohberger. The main suspect in that quadruple homicide in Idaho is a native of Monroe County, Pennsylvania. So we take this opportunity to take a deep dive into the documents being filed in this case and follow it as we look ahead to an eventual trial, which is still scheduled for October of this year, 2023. But since we last had an episode of this show, there have been a lot of big changes that could affect that October trial date. The big one, of course, is that we now know the prosecution will seek the death penalty against Kohberger. And we had a story on Newswatch 16, and we can link in this story here that basically said that Kohberger will be given a lot more time and given a lot more chances to go over the evidence against him heading into the trial now that it's a death penalty case, because he has so many more appeals rights when his life is on the line, basically. And that's one of the things that we're going to talk to an expert about today. The big news we want to talk about is that there won't be any news for at least a month now, because one of the things that Kohberger and his defense team had asked for was a stay in proceedings, basically putting the pause button on his right to a speedy trial to allow them to do some things. And the judge earlier this week granted him that stay in proceedings with an asterisk next to it, because there's a bit of an exception. He will get a stay, but not for as long as they had hoped. Let's take a look at this amended order granting the stay in proceedings. If you read the whole document, it states that Kohberger and his defense team had asked for that stay for two reasons. One, to question the grand jury selection process, that grand jury indicting him a couple of months ago, and that was a step in the judicial process. And also putting a stay in proceedings because they wanted a chance to look over the materials that the grand jury was presented. And the judge denies a stay so that they can question the jury selection, but does grant them a stay to go through the records. This second paragraph here says, nevertheless, the court recognizes that Kohberger has the right to review the grand jury materials to determine if there are grounds for challenging the grand jury selection process. This is a complicated, unusual case, and it has taken some time by no fault of either party to prepare for grand jury materials that the Kohberger is entitled to. So that stay is only 37 days. It started on July 6th and will go into beginning of August. I can't see the exact date here, but it's about the first week of August. And then we do know that there will be hearing on August 18th to go over some discovery pieces of this case. We wanted to get a take from a defense attorney about what this stay really means. 37 days. Is that the time that he needs to really prepare all of these materials? And how might that affect the trial? So we talked to Brett Regal, who's a defense attorney from Monroe County, about how this might affect the case.
Brett, thanks for joining us again and providing your legal insights. First, are you at all surprised that the judge in this case granted the stay of proceedings that Kohberger was looking for?
No, once you read the order, it makes sense. Essentially what the judge said is, you're asking for relief now, but you haven't had the opportunity to review all of the materials that would support either a well-founded request for relief or cause you to say, I really don't have a basis to ask for anything. So rather than trying to do it on sort of half a record, I'm going to give you time, but that time ends up extending the state's speedy trial obligation. So essentially what the judge did is he said, look, we're going to count 37 days out. And right now we're going to leave the trial as scheduled in October, but we might end up having to move that trial date back. And those 37 days count against Mr. Kohberger rather than counting against the state.
Mm-hmm. If any of our viewers go in and read that paperwork, it explains the Idaho speedy trial law pretty succinctly, that basically they have 6 months to take him to trial. Followers of true crime and of court processes I think would say 6 months. That almost never happens. Is that the law in Pennsylvania as well? And what are the things that can affect that?
So the answer is sort of in terms of whether or not it's the law. I say that because Pennsylvania's rule regarding a speedy trial is codified in Pennsylvania Rule of Criminal Procedure 600. And what it basically says is if somebody is in custody, yes, we are to get them to trial in a 6-month window. In general, a year, if they are out of custody, there is an issue regarding when nominal bail is available depending upon the type of crime. But the way that it works, and it looks like Idaho works similarly, and I'm not surprised because most states do, is that we have what they call an automatic run, and then there can be extensions or modifications to that. The automatic run is you plug in the date that the first piece of paper was filed, it spits out a date by which you have to have gone to trial. That's automatic. Now, in there, things can happen that can cause that to be extended. Examples are if we're waiting on DNA evidence to come back from a lab and the defendant says, I'm okay to wait. I want to see those results. I don't want to force the state to move ahead or to cause the lab to move me up in the queue or anything of that nature. Or I'm filing a motion that suggests that the statement that I gave was given as a result of duress or coercion, and I want the court to decide that that statement can't be relied upon in my case. Those types of actions by a defendant necessarily extend the time because it's certainly not fair to the prosecution to be told, well, you've got this very limited time to bring this person to trial, and then turn around and say, but they're the ones complaining of something and asking for relief, and we won't extend it. We in Pennsylvania, it is essentially automatically extended when certain things are filed. Sounds like here in Idaho, it's more a matter of you have to bring it to the court, and then the court decides whether and by how much to extend it.
Mm-hmm. Now, I expect because now we know that the prosecution is seeking the death penalty, that we're going to see this quite possibly several times before we actually get to trial, right? That this moves the goalpost quite a bit.
The death penalty probably does move the goalpost quite a bit. This particular item, it appears that what happened is he got some of the discovery, but he did not get everything that he is entitled to, because apparently there's the opportunity, if deemed appropriate by his defense team, to challenge the way that the grand jury was created, was what it heard, whether or not all of the procedures and protocols were properly followed, etc. And he apparently can't know that until he sees what the transcripts of the grand jury proceedings were. Pennsylvania, by contrast, you actually can't get grand jury proceedings absent a special order of court until the person that appeared before the grand jury is actually testifying, and then you are provided at that time a copy of their transcript from the grand jury proceedings. So there's not, some of the things that are built into Idaho's procedure don't have a really clear correspondent in Pennsylvania's procedure.
I understand. I also think if from someone who is just observing all of this happening, it's kind of surprising to me that his defense team is having to file for discovery so often. I think there are 6 or 7 now motions to compel discovery. Shouldn't that be automatic? That information is shared between the defense and the prosecution?
A little bit difficult to answer, only because the requests are sometimes related to what it is that they've been given in part. Like they might have been given all of file A, and file A causes them to believe that there's file B, C, and D out there. And from the state's perspective, B, C, and D didn't relate to or directly relate to this prosecution. It didn't contain anything inculpatory. and it didn't contain anything exculpatory. So the state said, well, we don't have to turn those things over. Some of it depends upon really the, how do I want to say it, the philosophy, I guess I'll say, of the prosecuting agency. For example, there are district attorney's offices and portions of the AG's office here in Pennsylvania who, if you don't identify specifically what you're asking for, they'll say, well, you didn't ask for it, so we're not turning it over. There are others who will say, literally, come to my office. You may go through my entire file and copy whatever you want. And then there are ones that are in between. The rules here set forth certain things that you are absolutely entitled to, and then other things that are discretionary with the court. So if we're talking about here being the example, if I didn't get those things in that first category, I'm going to file a very generic motion to compel that says, hey, I'm entitled to A, B, and C, and I didn't get them. If I know that there are things that exist, or I suspect that there are things that exist that fall into that discretionary category, if the DA didn't voluntarily turn them over, he didn't do anything wrong, but I have to go ask for it. Some DA's offices take the philosophical approach of, we'll just give you everything and let you figure it out. Others take a more approach of, the rules say this is what you're entitled to. We would never withhold this. Here are things that if you want them, you've got to ask for them and get the court to approve them.
And I'm sure there's strategy from each one of those prosecutors as to what their approach is.
And sometimes it's a matter not even just of strategy, but of not yet having the full picture, because they're waiting for things to come in. In fact, the judge even comments in this order that this is a procedurally unique case, and it has come up very fast. I mean, we may be sitting out here going, wow, it took them a long time to charge him. But when you look at what went into the investigation, it's kind of important to remember that while there is a CSI factor, we also don't turn to a lab and go, give me DNA, and tomorrow it's here. It just doesn't work that way in the real world. It works that way, you know, in television shows and movies and things like that to keep the plot moving forward. But that's not how it works in the real world. And so, you know, some things that they are hoping to have, they may just not have yet. And so they don't necessarily want to give away a certain item until they know how it fits with the rest of it, because that can create what we commonly call red herrings for everyone. You know, the defense gets very excited. Oh, we're missing XYZ. You weren't missing it. It just didn't come back from the lab yet.
That was Brett Regal from Armed Lawyers in Stroudsburg, Monroe County, talking about the latest developments in Kohberger's case. And the big one that we're talking about is that stay in proceedings, which means that there won't be much news until the hearing that's scheduled. Again, that's August 18th in Idaho court, where the judge, the prosecutors, and the defense team will all be at the table to talk about discovery, what evidence Kohberger can see and when, and kind of hammer out the next few steps before trial. So we will have coverage of that hearing on August 18th, and we'll be here for all of the developments. Thanks for tuning in for another episode of Case of Interest Kohberger.